I'm Sam Butcher, the founder and owner of Butcher Elder Law. The topic that I'd like to discuss with you in this video is powers of attorney and living wills. First, let's consider a healthcare power of attorney. To begin with, we refer to these powers of attorney as durable healthcare powers of attorney. The word durable in the context of a healthcare power of attorney has a very specific meaning. It means that the power of attorney survives the disability or incapacity of the principal, the individual who created the power of attorney. So obviously, the time when the principal most needs his or her healthcare agent to be able to act is when they become disabled or lose capacity. So it's important that the healthcare power of attorney be durable. Some people think that powers of attorney, including durable healthcare powers of attorney, are no big deal. Well, it turns out it's a real big deal. Why is that? Well, in the case of a durable healthcare power of attorney, we actually refer to this as the God power. Why? Because you are giving your agent the ability to make what could be life-saving or life-sustaining decisions for you. Your healthcare agent may find themselves in the position of having to give consent or withhold consent to treatments and procedures that may on the one hand be life-saving, but on the other hand carry with them a tremendous amount of risk. And that's a very difficult position for your healthcare agent to find themselves in. And that's why it's important, first of all, that they have all the power and authority that they need to make decisions for you at a time when you are simply unable to articulate your own decisions, even if that's just temporary, but also to know how you would like them to act in certain situations. A healthcare power of attorney also deals with end-of-life decision making. When we sit down with our clients to create a durable healthcare power of attorney, we have a very detailed discussion with our clients about what they want or do not want when it comes to end-of-life decision making. If they're in a terminal condition or if they're permanently unconscious. And those terms, terminal condition and permanently unconscious, have specific definitions as they are used in these documents. But there's something else that we consider very, very important to individuals and families, and that is that we don't ever want that healthcare agent to be in the position of having to make a decision, an end-of-life decision, to discontinue life-sustaining treatment or withhold consent to providing life-sustaining treatment, to, in essence, pull the plug without knowing what the principal really wants in that situation. And we strongly admonish our clients not to put their healthcare agent in that position. So what do we do about that? Well, that's where a living will comes in. The difference between a durable healthcare power of attorney and a living will is that the living will is your own publication of what you want to have happen or not happen if you're terminally ill or permanently unconscious. The fact that you give your healthcare agent authority to reinforce that decision among your physicians and other healthcare providers in a durable healthcare power of attorney is important, but don't leave your healthcare agent with the burden of having to make that decision for you or having to be the only person who can articulate your wishes to your healthcare providers. Do it in a living will. Do you all remember the Terri Schiavo situation? And do you remember what happened in that situation? Terri had been in a coma in the state of Florida for over 4 years. And her husband said that she had remained in that state permanently, a state of permanent unconsciousness, long enough. And it was time to let her go. And her parents opposed the husband's decision. The real problem was that nobody knew what Terri wanted because Terri didn't have a living will. Well, eventually that case was resolved, but not until after Congress stayed up all night and the courts became involved. And so the lesson learned from that story is don't put your family in that situation. Create a living will in conjunction with a durable healthcare power of attorney. The financial power of attorney also needs to be durable so that the agent is able to act in the event of the disability or incapacity of the principal. But you know what we call a durable financial power of attorney? We call it a blank check. Would you give a blank check to someone? Probably not, because with a power of attorney, they have something that's actually worse than a blank check. They can't just deplete your checking account. They can sell your home. They can convert all of your assets because a lot of the powers of attorney we see just provide a long list of authority and absolutely no instruction at all. And yet some of these powers of attorney don't contain the specific powers that are needed to protect assets for the principal. So, a couple of simple rules that we follow in our practice when it comes to creating durable financial powers of attorney are these. Number one, we want to make sure that there is a very expansive list of authority conferred on the agent so that the agent can act to do everything that needs to be done for the principal in the case of a disability or the principal's incapacity, particularly in order to protect the assets of that individual and help that individual to qualify for government and other benefits. Number two, we want to make sure that that durable financial power of attorney is tied in with some instructions, specifically with the other estate planning done by the principal, so that if there's a need for gifting, which sometimes occurs in order to qualify the principal for certain government and other benefits, that gifting has got to be consistent with the overall estate plan and benefit the intended beneficiaries of the principal. So those are a couple of rules that we always try to follow. Now, are all powers of attorney alike? Well, I think I've already alluded to the fact that they are not, and so you need to pay particular attention to this most important subject to make sure that the power of attorney that you have drawn up is going to be all that you need when the time comes that someone needs to exercise that power of attorney on your behalf. So having a durable financial power of attorney, a durable healthcare power of attorney, and living will are very important documents when it comes to a comprehensive estate plan and remaining in control. For more information about these subjects, please reach out to us. We'd be happy to sit down with you and discuss it in further detail. Thank you.